Welcome, everybody. Welcome to Sidebar with Judge Dan Winslow. I am Dan Winslow, formerly of the Massachusetts Trial Court, now with the New England Legal Foundation. We've got a great show for you today on digital privacy in a dangerous world. And before I introduce our guest this week, I want to just go over a few housekeeping matters. If you are new to Sidebar and new to Fireside, we have a great platform here. And I see we've got Frankie and Joanne and Lily and a number of other folks joining us in the audience. Thanks so much for joining us today. If you're new to the app and on an Apple device, in the lower left-hand corner of your screen, you'll see an equal sign. And if you click on that equal sign, you can actually ask to join us on stage. And we'll be happy to have you come up on the stage. You can ask a question. We'll kick you off after you ask your question nicely, of course. But then we'd love to have you participate with us in the conversation that we're doing. And hey, Jen Franks, would you mind just updating our fortune cookie as well with the website so that folks can contact us as well? And then on the lower right-hand side of the app, you'll see an emoji with a react button. And if you click on that button, you'll see a range of emojis: happy, sad, indifferent, surprised. And if you click on an emoji, you can actually type in the chat box and send it to us, a question in writing. So if you don't want to jump on stage with us, but you have a question that you'd like to have asked, happy to read your question out to the guests and have them speak to it. In fact, on that emoji button, why don't we just practice? If you click on that emoji button, you'll see in the upper right-hand side an applause emoji. And if you just click on that, and hit send. So you just try that again. Now, I think that was a very tepid round of applause. I think we have to just hit the applause emoji again and hit send. Give it okay. That's better. I always like to start the show off with a round of applause. So, what I'd like to do is to introduce our incredible guests here today. We're really honored to have people of great consequence and caliber in their fields. So, first off, we have a couple of other. This is a legal show, but it's not legal advice. So anything that we say here does not constitute legal representation. If you need counsel, by all means, we ask you to speak with competent counsel. We just happen to know that the law firm of Jones Day is full of competent lawyers, and we commend their services to you. Today's show is sponsored by Jones Day, and we're thankful for their support of our efforts. We have from Jones Day Mauricio Paez, who's a digital privacy lawyer. Mauricio, why don't you just introduce yourself and share a bit about your practice?
Thanks, Judge. Welcome, everyone. Really excited. Thank you for coming on, and certainly I underscore the invite if any of you want to jump on stage. I hope you hear me loud and well. I'm a partner here at Jones Day in the New York office. I'm in the cybersecurity, privacy, and data protection practice. I've somewhat embarrassed to say I've been doing this for over 25 years, but it is my pleasure, and I'm looking forward to having a spirited discussion.
So Mauricio started practicing digital privacy when he was 5 years old. Really well done, by the way, Mauricio. We also have from the United States Privacy and Civil Liberties Oversight Board, which we'll talk a lot more about. We're just honored to have the chairperson of that board from the United States government, an independent federal agency. And Sharon, I've said before that I think that your agency probably is one of the most important and yet least known federal agencies in the United States government. So why don't you introduce yourself and tell us a bit about your agency that you oversee? Oh, and I think you're on mute, Sharon. We'll have to unmute you.
Am I now?
We're good.
Okay, great. So thank you. I'm Sharon Bradford Franklin, and I am also an attorney and have a long background in various issues involving national security and privacy and civil liberties, both inside of government and also in the nonprofit sector. And I had previously, I was appointed as chair and confirmed in February of this year. Previously, I had served actually as executive director of the Privacy and Civil Liberties Oversight Board from back in 2013 through 2017. So have a lot of experience with our agency. Our agency, as you said, a lot of folks don't know about it. It was created based on a recommendation of the 9/11 Commission. and Congress created the agency as an independent agency back in 2007, but it then took a full 5 years before the agency actually came into existence. We are headed by a bipartisan board of 5 members. All of those members must be appointed by the president and confirmed by the Senate. And it took until 2012 before we got any members to be both appointed and confirmed and for the agency to come into existence. The agency's mission is to review federal counterterrorism programs to ensure that they have appropriate safeguards for privacy and civil liberties. And there's, so in large part, we are an oversight agency. We also have an advice function where federal agencies that operate counterterrorism programs can come to us as they are developing those programs or making changes to seek our advice. But the most obvious and public-facing role is as an oversight body. And a couple of other quick points I'll make. I know we're going to get into more details as the conversation goes on, but a couple of other quick points at the outset. One is that our role is not just to review compliance with existing law and safeguards. And I don't mean just in a pejorative sense, but just in a limiting. We do look at that, but we also make policy recommendations. So even if an agency is operating in accord with existing law, are there appropriate privacy and civil liberties safeguards? Can they do more without undue detriment to the national security purpose of the program? Another quick point just to make at the top is our jurisdiction is grounded in counterterrorism. We were created, as I mentioned, based on a recommendation of the 9/11 Commission. But when government activities have multiple purposes that include counterterrorism, that is within our jurisdiction. So it is not narrowly, totally limited to counterterrorism when there are, and many surveillance in particular activities have multiple purposes to include counterterrorism. So that is within our jurisdiction. So I'll stop there for now, but happy to. I know we'll talk a lot more.
We have so much to talk about. I want to come back to you, but I don't want to give short shrift to our third person on the stage with us, Alan Silverleib, who I was very fortunate back when I had hair to work with. And Alan, I know you have had an illustrious career in the State Department and also with CNN, and now you've brought your considerable talents here to this important agency. And so, just want you to say hello to folks and introduce yourself a bit.
Sure. Thanks a lot, Dan. And if I recall, when we worked together, I think I had hair back then as well. So I guess there's a lot of water under the bridge there. But no, you pretty much said it well. You know, I was at the State Department for the last 7 years. Prior to that, I was with CNN for a number of years. And then, of course, before that in Massachusetts state government. And I just started with the PCLOB, with the Privacy and Civil Liberties Oversight Board, back in April. So I handle public and legislative affairs for them now, and I am thrilled to be able to work with Sharon and to call her my boss now. So I'm just looking forward to the conversation.
And it's wonderful. And thank you all for being here. And Joanne, I'm going to get to you in just 1 second, but I just want to kick off the conversation by pointing out this from the website of the PCLOB. It's a PCLOB.gov website, that the 9/11 Commission observed that the recommendations called for by the 9/11 Commission called for the government to increase its presence in our lives. For example, by creating standards for the issuance of forms of identification, better securing our borders, sharing information by multiple intelligence agencies and the like. And the Commission observed that this shift of power and authority to the government would also require some enhanced systems of checks and balances to protect the precious civil liberties that we as Americans enjoy and rely upon, that are so vital to our way of life, and found that there currently was, at the time of the 9/11 Commission, there was no office within the federal government whose job it was to look across the landscape of government to the actions that we're taking to protect ourselves from essentially government overreach. And to fill that gap, the 9/11 Commission created this commission. And there have been different iterations of it, but now the final form of it now is it sits now as this PCLOB, the PCLOB board that Sharon chairs. And I'm curious, Sharon, as chair, what keeps you up at night?
Oh, that's a great question, grounded in that. So yes, just to start with your the predicate to your question. We are, as I should have clarified, an independent agency within the executive branch. And so this role that the 9/11 Commission envisioned, that then Congress carried out with the legislation that created us as an independent agency. So it is, I think, a really important role, because as part of the executive branch, we are able to get access to information from the intelligence agencies and other agencies that operate counterterrorism programs, and be inside what they call the deliberative process privilege. We are part of the executive branch, so we can protect those internal deliberations appropriately. Yet we are independent, so we can, without fear of consequences from agency heads, say what we think. If we think a program is illegal, if we think a program needs more safeguards, we have that independence to opine on that. So it is, I think, a really critical role. There are other oversight entities, of course, from Congress, from inspectors general, and so forth. But we do play that critical function. In terms of what keeps us up at night, we are an oversight entity. So we are not the ones who are on those front lines to protect us from counterterrorism threats or other threats to our nation, but we do review those programs and ensure that the balance is appropriate. So we do get insight into what those threats are. So, but our role is really to make sure that the paired threat to our rights and both constitutional, statutory, privacy rights, coming the Fourth Amendment, First Amendment activities, and so forth, are also protected, and that our government is getting that balance right.
And it's not just, one perceives terrorism as an overseas threat, but there's also been a focus, at least of late, and I think really since Oklahoma, on the danger of domestic terrorism as well. Does the PCLOB also focus on the domestic agenda as well and protect? I would think there'd be actually a more enhanced need for civil liberties oversight there.
Yeah, that's a great question. So we have, our government, as you referenced, has had an increasing focus on domestic terrorism in recent years. And we have also at the PCLOB made clear that we need to address this. We just this spring put out a public notice seeking comment from members of the public on, as we address the government's efforts to protect us from domestic terrorism, how do we also safeguard privacy and civil liberties, and what kinds of oversight, what issues would be appropriate for our oversight. That public comment period is open until June 30th. You already announced our website, so people can find details about that, and who want to submit comments to us. The public comment period is still open through the end of June, so we would welcome those submissions. We also held an online public forum on May 26th to examine those issues. We had 3 panels. First, a panel of government representatives who spoke about their efforts to combat the threats from domestic terrorism and what safeguards are built in. And then 2 further panels of outside experts raising and discussing some of these issues with First Amendment, Fourth Amendment, also with what are emerging technologies that are used and what threats do those pose, and are there risks of a disparate impact on particular protected groups? So a variety of questions, and we are going to be working once the public comment period closes to scope and define our efforts on oversight in this area. Because
so we have a question actually from Joanne. Joanne, I'm going to invite you up on the stage, and this really goes to the question of emerging technologies. The question that I had is, as the technology changes, and it can change so quickly, the oversight function has to, keep pace with the changes of technology, which has been an ongoing struggle. Joanne, thanks for joining us on stage. What's your question about Web3 and blockchain?
Well, can you hear me, guys?
Sure can, yeah.
Okay. Yeah, no. I'm just questioning, because it really is such a different way of doing things, and it really does keep privacy. It takes a lot of energy, and I just wanted to know where you see that going. I mean, the financial industry is going to change within the next years because of blockchain technology. So I was just wondering, in terms of security, in terms of digital privacy, because that is exactly what blockchain addresses. So where do you see that going? You know, it's like 5 or 10 years ago. Just so you know, I'm a retired software developer, but during the dinosaur age, okay, I have a legal background. And basically, you know, even 10 years ago, we were looking at blockchain in the financial industry, and eventually it will probably take over clearinghouses. So where do we see that in defense for us? Where do we see that in terms of our rights to privacy, which I don't believe we have any, but, you know, so there's a lot. So are you guys looking at that? Because it is coming. Not Web 3.0, but Web 3. They're two different things. So curious.
Yeah, thank you, Joanne, for that question. And Mauricio, I'm going to turn that one over to you initially because it does spill into the private sector as well. And just interested in your thoughts about Joanne's question. And then Frankie, I see you there. I'm going to get right to you next.
Well, Joanne, I would say that you do have privacy rights. It's just that they're evolving. And quite frankly, I think that some will say that with respect to the emerging technology space in particular, that we tend to think about, privacy sphere, rights in controlling your digital self, and the relative risks in terms of the relationship between individuals and governments and individuals in the private sector and individuals among themselves. And of course, we live in a global landscape. We talk about dangerous world. Well, this is a dangerous world everywhere, right? And we're dealing with a lot of increased sophisticated threats. We're dealing with a fast adoption of technology and proliferation. You're talking about Web 3, which is really a concept of decentralizing the global internet. Beyond Web 3, we're also talking about providing artificial digital barriers across different jurisdictions and different types of services. And so I think that, and then Sharon, get your thoughts on this as well, but there is a high level of complexity, right? We're talking about the differences between state and government's ability to actually collect data and have legitimate law enforcement needs with respect to that kind of data collection. And then there's the private sector. Some would say the vast adoption and the mass data aggregation means that in fact private industry has more greater visibility and risks than government. In some cases, and you see a lot of those arguments being made. And so I think that for blockchain, smart contracts, these technologies, like any technology across our experience, can either enhance or restrict or make it more risky, right? It all depends on the technology adoption and how that technology is actually implemented, it's being used, how pervasive it is, and the role that private and public, including public-private partnerships, play in how to deal with it. And of course, the evolving concepts of what is considered private in the digital space, right? We're still going through that evolution. Even in the context of smart contracts or even a decentralization of the internet where you have greater control over your data, what does it mean to have control over your data? What does it mean to actually be your data? And we'll see a lot of policy in the US in particular, but certainly we're a bit behind when it comes to the international standards around data privacy or data protection, is that there's an evolution taking place about what is considered private, what is considered personal. And how do you sort of protect the data? And what individual empowerment should you have when it comes to transparency and visibility and redress around the data collection and data use cases? And again, difference between private sector versus the public sector. Now, I will tell you that, all of this is my personal views on this because I don't speak, none of what I've said should be attributed to my firm. But I will tell you that personally, I think that we're always going to have policy and law trail behind. We're always going to have the law really think about how it adapts to this sort of evolving technology, evolving adoption, and evolving use practices and evolving risks. And of course, with new technology opportunities, new data, new value propositions, comes opportunity for greater threats, greater risk, greater interception, greater intrusions. And so we have to find a way to strike that balance. Today, we're talking about what we live with today, right? With mobility, with international data acquisitions, with foreign, surveillance and counterterrorism and legitimate law enforcement needs based on the current state of technology. But Web3 and the mass proliferation of things like smart contracts and other blockchain type technologies and, might I say, intelligent systems, right? Artificial intelligence, it's going to really continue to push the envelope. It's going to raise a lot of questions. And it isn't just going to be a domestic issue. It's going to be really a global issue because the internet, despite what you see and what you hear about evolving policies in other jurisdictions where they try to provide, impose these barriers on the internet, the vast majority of democratic society still believe in an open internet. We just had a declaration of the future of the internet where all major economies, the U.S. included, signed a declaration to push policy to continue to allow for free flow of data.
I want to ask Mauricio though, and this goes to Sharon's jurisdiction as well, because I understand that the technology is evolving, and yes, I think law and policy and probably regulation and oversight even needs to always be chasing technology, which is continually evolving. But the boundaries of the lines that is between government and the private sector seem to blur because in part, and correct me if I'm wrong, in part, the government does leverage private sector data as well. So, if there's phone records or internet records, the like, our intel agencies will reach out and ask to have, that information. So, Sharon, as the oversight board, recognizing you're not blocking, you're not the law enforcement of the law enforcement, but in your world, how do you try to grapple with that boundary? Do you try to create bright lines? Do you recognize the blur and then just go with the blur? How do you deal with that reality?
So our role, as you noted, is oversight of the federal government. So any department or agency that operates programs or activities that include counterterrorism as a purpose and focused on the counterterrorism purposes. It's not unrelated, as you note, because several authorities, so for example, there's the Foreign Intelligence Surveillance Act, or FISA. And through various provisions of FISA, that authorizes the government to seek information directly from communication service providers, tech companies that will have people's information. Right. And there are standards they have to follow to get that information, but they do get it directly from those tech companies. And so to the extent that those tech companies are gathering more information and have that in their holdings, that increases the potential for what the government can get when it goes through the tech companies to get people's information. So that's where the relationship is. But when we do oversight, we are doing the oversight of the government's actions and making our recommendations directly to what the government should do.
Interesting. Okay. Well, Joanne, thank you for that question. We've got Frankie J is asked to join us on stage here today. Frankie, what's the question or point that you'd like to share with us today?
Hey, Judge. Thank you as always for having me up. My question is this, and I'm not, forgive me if it doesn't relate directly to what you guys have talked about. What kind of protocols or policies are going to be put in place with, Web 3? I'm still catching up on Web 1 and Web 2, so I'm a little bit behind in times on cyber squatting, where, you're at home, you're branding, you're building a business, and you have people snagging, domains and things of that nature. What kind of protection is going to be put in place for people that deal with that certain issue?
I'll leave that one to you, Mauricio. That's I think squarely private sector issue, but any thoughts on that? And Frankie, thanks for your question.
Thanks, Frankie. So it's going to be a really interesting and complicated question, right? Because we go back to the before the Anti-Cyber Squatting Act, this practice of usurping brands and names, and in order to, derive value out of it. And of course, Web3 is going to provide that kind of opportunity where you are going to be able to get, or at least risk that individuals will adopt famous brands and use them to generate value. And I think the mechanisms already exist for purposes of bringing enforcement where there is, illegal use, I would say, or improper use of another brand and that infringes on someone's rights. And so I think that there will need to be some evolution associated with the mechanisms and the opportunities that exist in order to enforce those marks. We have a very complex system today, which has processes and rules around how domain name holders can be subject to complaints with respect to the use of their marks in the domain name registration system. And of course, we have the Anti-Cyber Squatting Act as well, which provides for remedies. And they're very broadly stated, but it's typically related to the domain name system. The challenge is going to be, how do we adopt that framework that's really tied to the domain name system into this very different system when it comes to the use of these brands and marks within Web3? And we'll see. Either we're going to find some way judicially through judicial action to accommodate those, or we're going to find some legislative way to deal with them. But those are going to be real issues. And again, a great example of how technology is moving so quickly, and yet we don't really have yet full answers to how to deal with some of these concerns. And now, just for purposes of our topic, sort of translate that to, is there an opportunity through Web3 or to blockchain to actually get greater control over your data, to restrict sort of access or sharing of your personal data, particularly where there is, value considerations, where you're trading on your personal data in this sort of new internet marketplace in order to get free products and services. And then how, and so the judge sort of asked, well, there is this core dependency between public and private. And you're absolutely right. And certainly in the U.S., the vast majority of what we sort of call, telecommunications providers, communication service providers, store communications providers, all these sort of different types of businesses are in the private hands, and the government, they need to get access to that data. And so where do you strike that trite, sort of interested stakeholder party? Certainly, PCLOB is doing the right oversight and addressing these issues, but ultimately, the rubber meets the road where you have these sort of contentions between the government saying, hey, company X, I need you to collect and store and save this data prospectively with respect to targeted individuals. And is that permissible? Can you force a private entity to prospectively collect data regarding U.S. citizens that gets stored in some application that then the government can have access through some dummy account or some other backdoor access, because they got a warrant to do it? And look, we've got a decision that tells us that no, that you only have a 10-day limit to do that moving forward. So we see that this partnership has to exist, but the law has to develop and catch up, and judicial scrutiny has to continue to develop and catch up to address these issues.
You make a good point though about the sort of that blurred line. So what I was reflecting is that in government, typically, sunlight is the best disinfectant. Usually, transparency is the key. When I was advising people in government, I would say, look always be transparent. Nobody will ever fault you if you're transparent. And yet, Sharon and Alan, you find yourselves in a governmental oversight function where transparency would actually be counterintuitive. If you can't be transparent so much about so much of what you do, so how do you strike that balance? I would think ultimately, by the way, if there's any civil liberties lawyers listening, like this PLOB or PCLOB or PCLOB would be like, this would be a great website to keep an eye on, because by definition, a civil liberties violation is a judicial harm. It's a constitutionally protected right, and therefore a judicial remedy exists within the judicial branch, I would think, with the plaintiff lawyers. But how do you balance the fact that the things that the things that keep you up at night that you're not actually doing, but you know about, and that the kind of the regulatory oversight, the protections, how do you balance these almost contradictory notions of transparency and secrecy?
So that's a great question. And the PCLOB's authorizing statute actually directs us to make our reports available to the public to the greatest extent possible, consistent with protection of classified information and applicable law. So right there, we are supposed to lean into that transparency function and help inform the public. Now, of course, some of our work, as you note, must remain classified. All of our board members and staff are required to have top-level security clearances so that we can access and review that information.
Are you top secret clearance?
Yes, we all have to have that. And we can be public about that. Some folks who have those clearances can't even tell you that they have them. but it is actually part of our validity as an oversight body to be public about the fact that we have to have those clearances and can access that information to conduct the oversight. But this does come up. So a great example is fortuitously, the timing of the PCLOB coming into existence as an independent agency with a full slate of 5 board members happened just before the initial Snowden disclosures. And so, and I shortly thereafter came on as executive director, as head of the staff at that time. And so folks may recall that one of the 2 programs that was the subject of the initial Snowden disclosures was something that's called Section 702 of FISA. And when we did a full report on that came out in July of 2014, and part of the role, and I think one of the main accomplishments of that report, was we worked very closely with the relevant intelligence agencies to see what information could be declassified in the public interest. And coming out of those Snowden disclosures, the government understood that it hadn't been very transparent about what the rules are. What are the rules of operation? Obviously, the details of specific targeting operations, specific intelligence collections, those need to remain classified. But what are the rules? What are the authorities? What is the government actually allowed to do? And so we worked very closely with the intelligence agencies and requested, under the executive order governing classification, declassification in the public interest. And we were able to put out a comprehensive report, which is still, kind of considered, the authority on what does that 702 program mean? What are the rules of operation to get that out there? Now, some things have changed since 2014, but it still is, I think, very helpful. And so it is something that we will continue to work on as we examine classified activities. What can appropriately be declassified in the public interest and what does need to remain classified?
So you mentioned Snowden, and just for the members of the audience, Edward Snowden was, I think, a military intelligence analyst who, in the private sector would be called a whistleblower, and in the public sector has been called a traitor. I know that President Obama had described him as one of the worst military breaches in some quarters of this country. He's considered a hero. But whether one agrees or disagrees with him or what he did or any of his methods, certainly the revelation of the extent of intelligence gathering that was happening and the capabilities of the government to know and to delve into what people would expect to be private communications was eye-opening. And I think that the timing of your agency's oversight function couldn't have been better. I mean, just to talk about the need, it's I've been in government. It takes years to get anything done in government. This actually happened in a relative blink of an eye to have it, because that's the importance of civil liberties, and people recognize it, regardless of what side of politics or the aisle you're on or anything. It's a common foundational value that as Americans, our freedom, our civil liberties, we all hold dear. And to sort of have that hanging in the balance against the very real need in a very dangerous world of people that want to hurt us, where do you strike that balance? So I don't envy you, Sharon. When I was in government, I was offered a top secret clearance at one point, and I declined because I just wanted to be able to go to bed at night, not worry about stuff that I couldn't immediately do anything about. Hey, Mauricio, you want to talk about 702?
Well, I just want to make a brief comment because oversight's critical. It's super important, and obviously the next step of oversight, which is disclosure, is just as important, right? And it's important on all sides. But really is how do you then, debate continues about how do you embed within 702 itself and within the relevant processes transparency? How do you build in greater minimization or relevancy? How do you build in sort of, disclosure and access on individuals when it comes to how some of the data is used? And how do you build in enhanced restrictions on sweeps of data collection that some argue continues to be a problem? We see some FISA courts sort of point out that that's an issue. Nevertheless, they still approve those. And so the question is, when 702 is going to come up for approval next year, are we going to see a more robust debate? Are we ready in the U.S. to have a more robust debate around how we surveil, how we collect this data, particularly around foreign intelligence, which is what 702 really is all about. It's just about how do you deal with it outside of the United States. But obviously, it's inevitable that's going to transmit to domestic data collection practices by the government. And given the close relationship between public and private sector, where a lot of the data comes from, the private sector? How do you reach the right balance with the private sector, who increasingly have become hostile? And I think in some cases, understandably, given the broad nature of these sort of requests that you're seeing from some law enforcement agencies to private industry, and what they want to collect and how they want to collect it and how they want to be preserved. I think that's going to continue. And I'm interested to get the sense from at least from the PCLOB sort of point of view of what are going to be the core areas of discussion, that's going to happen. And do we anticipate a really robust debate, or are we going to have what we had, 2-4 years ago, where there were some observations, but really there was such political polarization on these issues that nothing really happened?
Interesting. Great question.
If I could jump in there.
Please,
so let me just start very quickly, because not all of your audience may be familiar with what Section 702 even is. So let me just start with a quick what 702 is, and then I'll speak to what the upcoming debate may look like. So Section 702 of FISA authorizes the U.S. government to target what are called non-U.S. persons, so people who are not either American citizens or legal permanent residents, who are located outside the U.S. So these are people who do not have recognized Fourth Amendment rights. And it allows them to target those individuals and collect the content of communications, emails, phones, and so forth. And when a U.S. person who has recognized Fourth Amendment rights is on the other end of a communication with a target, right? The target can't be Americans. But if a U.S. person is on the other end, then their communications can be collected, what the government calls incidental collection. And then once the government has that information collected, it can search through the collected information, including looking for the information regarding specific U.S. persons. That is a procedure that the U.S. government calls conducting a U.S. person query. So it is querying its database using a term associated with an identified U.S. person. And it is a term that many privacy advocates and some members of Congress have called backdoor searches. And this is going to be an area that is very likely to be front and center in the upcoming debate. As Maurizio noted, Section 702 is scheduled to sunset or expire at the end of 2023. And so Congress will have to either reauthorize it, let it expire, or amend it. And so just to one key issue that is anticipated to be at the heart of that debate, or at least one key issue, is this question of what should be the standards for when the government conducts what it calls a U.S. person query. Right now, there's no court review. So one thing I neglected to mention is under Section 702, the government has to get annual approvals from the FISA court, which operates in secret, fully classified information, has to get annual approvals for what are called certifications, or the categories of types of collection, things like counterterrorism, weapons of mass destruction, and also gets approval for things called targeting procedures, minimization procedures, and querying procedures, basically the rules of operation of the program. But the government does not ever seek approval from the FISA court for any particular targets. That is not something, because and the theory there is those individuals don't have recognized Fourth Amendment rights. So then when the government goes through the collected information, and if it's looking for information about a particular U.S. person, so someone who does have Fourth Amendment rights, should they have to go to the FISA court or otherwise get that approval at the back end under an enhanced standard? And right now, the standard requires that the government analyst finds that the information, the query term is reasonably likely to lead to the return of foreign intelligence information, but it's not a probable cause standard or seeking court review.
So is that still within the executive branch agencies, or is that, at what point does it go to the judicial branch, which is our traditional check on the executive branch for oversight and overreach?
So the judicial branch here is represented by the FISA court. Right. The FISA court, it does operate in secret to be able to review classified information, but it is, the judges are traditional, what we call Article 3 judges who serve on the FISA court. But the FISA court is solely looking on an annual basis at these certifications, the topics, the targeting procedures, the minimization procedures, and the querying procedures. So they are not ever looking at individual targets, targeting decisions. Are those appropriately made under the targeting procedures, or what queries? they're not looking at those and approving those before the government does
That's
those. So those are done entirely within the executive branch.
That's interesting. I just want to, first of all, I want to say thanks to Frankie and Joanne for your earlier questions. I want to welcome Lily, Lisa, Char, Ray, Tammy for joining us in the audience as well. And by all means, folks, feel free to jump into this conversation with us by asking to join us on stage. One question, I know I'm going to get back to you, Mauricio, but one question that I had is, to the extent there is political pushback on whether 702 should be reinstated or changed in some way, and probably you couldn't reveal exactly what happened, but it'd be interesting to know, has the section as it currently exists, recognizing the concerns, but as it currently exists, has it been efficacious? Has it been effective in protecting us? Has there been some plot, some theme, some plan, some conspiracy where we could demonstrably say, you know what, this saved lives, this protected us in the United States? And if so, sort of work backward from there to say, okay, now what about this thing you want to change, Congressman or Senator? Because it actually worked, it actually protected us, and to try to use that intelligence, that data, if you will, to maybe fine tune the law. Every law is capable of improvement, of course, but I'd be curious, has it ever worked the way it's been done to protect Americans?
So I'm not sure who they're addressing that question to, but I can say when the board, when the PCLOB looked at the program back in 2014, it did certainly find that the program had been efficacious in regard to counterterrorism protection and other protections that we were briefed on. That is something certainly the government is working to be able to brief members of Congress on those use cases and examples where it has been helpful. But to your point, the question for Congress won't solely be a yes, no, reauthorize or not, but can there be appropriate additional privacy and civil liberty safeguards, for example, that won't unduly undermine the program's ability to protect us? Can we build in further safeguards and strike a better balance?
Great. Mauricio, I know you want to jump in on this. Yeah, what's your point, sir?
Yes, I was going to say, there's no question that it's worked, right? And it just look no further than the intelligence community and the Bureau's advocacy of maintaining 702 because they love querying that. I mean, that's one of the favorite things. They believe that it has been incredibly useful and helpful to them in fighting crime, both domestic and internationally. The question is, what's the right balance? And as Sharon was pointing out, is it appropriate? Is it correct to say that the approach that we have today with respect to disclosure and minimization and redress, is that sufficient for purposes of the querying that's taken place? Do we need something different? There was a bill that was just introduced by Leahy that seeks to put some further limits on these certifications and disclosures, on the standing sort of requests. And I think that's, when we saw the prior debate on the authorization, there was some amendments that were proposed, and before then, you couldn't even talk about potential amendments. Either it's going to get reauthorized or not. So it was, to my surprise and to everyone else, that one amendment went through by over 60% of the Senate vote. That, to me, signaled that there is now a Republican indication that their willingness to address some of these privacy issues. And it used to be that it was very polarized. So I suspect that there will be some more willingness now to discuss privacy protections, some civil liberty issues in the context of not just FISA, but other areas. And in fact, there was a bill that was introduced just this month to try to provide comprehensive private sector protections enforced by the FTC and the state attorney generals for consumer privacy. And it's called the American Data Privacy and Protection Act, right? The intent is to provide for things that we're talking about: transparency, redress, accountability. So that's all what, we as a society think is important. Congress believes it's important to be thinking about and discussing and debating with respect to the private sector. But why not the government? So I think that there is going to be, and law enforcement in particular, so I think there's going to be some more debate around it. So I do think that oversight is critical. And in fact, I would, forgive me for saying that, but for PCLOB sort of reporting and transparency and assessment, truthfully, we won't know much of what's going on when it comes to, these programs, right? And so, is there a role for greater external independent oversight besides these sort of areas? And I think that, in addition to what Sharon said, would be a really interesting but yet really important debate. And let me just say one last item. that we truly are, I think, from my perspective, a bit behind when it comes to the international standard on data protection, when in digital space, when it comes to digital privacy. And we have a very complex patchwork approach of financial services, healthcare, some communications, some consumer protection. Then we have states that are having their own sort of set of rules on breach notification, on privacy protections and disclosures and things like that, right? But quite frankly, we're behind when it comes to the comprehensive approach on these issues, both for federal and state, when it comes to our trading partners in the digital trade area.
Mauricio, we're going to have to save that. That's a great topic for another show because that's getting purely into the private sector. But believe it or not, folks, we're at time for today's show. And I want to thank you, Mauricio, and Jones Day, our sponsor. I want to thank you, Alan, for helping to arrange Sharon, the chair of the PCLOB. What a fascinating and challenging mission that you have, Sharon, you and your colleagues on the board. As Americans, we wish you well in your mission and thank you for your service. And thank you all for joining us here today. My thanks to Joanne and Frankie for your questions on stage. Next week's show on Sidebar, we're going to be talking about mental health as a health issue. And we'll actually be opening it up for the audience discussion about throughout the entirety of our society, the challenges of mental health, the failings of mental health as a health issue in the United States, and we will look forward to that conversation. For today, my thanks to Alan Silverleib, Sharon, Sharon Brad. I have the same middle name as you, by the way. Bradford, Sharon Bradford Franklin, the chair of the PCLOB, and you, Mauricio Paez from Jones Day. My thanks to each of you for your contributions, your thoughts today. I'm Judge Dan Winslow. This is Sidebar. Do justice.
Thank you.